There's some developing news that may turn out to be good news for Virginia criminal defendants in certain criminal proceedings. So I want to let everyone know about some interesting changes that are likely to happen in the Commonwealth of Virginia. I'm attorney Drew Page, partner and co-owner of the law firm Randall Page, and author of the book, The Right Defense for a Traffic Offense in Virginia. Link below in the comments if you're watching this on Facebook, or there'll be a link to Amazon in the description if you're watching this on YouTube. But let's get right to it. So, as we know, the Virginia Commonwealth is currently under Democrat control and is looking to be that way probably for the foreseeable future unless things shake up in the coming election. But we've gotten some news. I was hit with a report by Virginia Lawyers Weekly, and that it is likely that certain criminal defendants who face charges that include mandatory minimum punishments may end up having the mandatory punishment requirement removed. So what are mandatory minimum punishments? Well, when you're found guilty of a crime, the judge will sentence you. Normally, they are presented with a set of guidelines. There's a pre-sentence report done. There's information gathered about the background of the defendant, the impact on the victim, different information regarding the family history of the defendant, what's his criminal history, any of those types of things, and that's all presented to the court. And then both the Commonwealth attorney as well as the defense attorney or the defendant representing him or herself are then able to they're able to present evidence and then argue about what a proper sentence should be, and then the judge will make a determination and sentence accordingly. And pursuant to Virginia Code, ordinarily for felonies, the defendant will serve at least 85% of the sentence that the judge gives. So if a judge gives a 10-year sentence, then the defendant will serve at least 8.5 years of that sentence. If it's a misdemeanor sentence, then the defendant, ordinarily, if he's sentenced to the maximum punishment of 12 months, would have to serve 6 months. All of this, of course, contingent on their good behavior in the jail and not causing any problems, getting any charges and things of that nature while incarcerated. But misdemeanor time is generally 2 days for every one. So what's different about mandatory minimum punishments is, first, that the judge has no discretion in the amount of time that they can sentence a defendant to. So, for example, a felon in possession of a firearm has to be sentenced to either 3 years or 5 years mandatory minimum. There is no discretion for the court to do that. For a DUI offenses where it's second offense, or if it's based on a higher blood alcohol level, the judge can only sentence must impose certain mandatory requirements. And that's even in a DUI first, for example, there's a mandatory minimum fine of $250. Where some other fines can be suspended, the mandatory minimum fine, they would have to pay the full amount. In certain other offenses like assault and battery on law enforcement, there's a mandatory minimum punishment of 6 months for assault on law enforcement. No matter how egregious it may be just that a person pushed a police officer and they were charged with a felony. Oddly enough, I've seen that happen. But then there's also times where someone punches a police officer or kicks at a police officer, things of that nature, and they have a mandatory minimum of 6 months. So, for example, that's a Class 6 felony, which gives a maximum punishment of 5 years. So instead of the judge being able to give 5 years with all 5 years suspended so there would be no active time, a judge would, at best for the defendant, would have to sentence them to 5 years with all but 6 months mandatory minimum as the sentence. So that's what a mandatory minimum punishment is. The other thing to know about mandatory minimum punishments is it's not subject to the 85% rule for felonies or to the 2-for-1 for misdemeanors. If you are sentenced to a mandatory minimum punishment, you have to serve every single day of that sentence. So if you get the 6 months mandatory minimum sentence, you have to serve each and every day of that 6 months for assault on law enforcement mandatory minimum. If you have the 3-year felon in possession of a firearm, you have to serve every day of that 3-year sentence. No discretion. It is what it is. You have to serve that punishment. So what is it that the General Assembly is looking at doing here? Well, there was a joint resolution number 48. Sorry, it was joint resolution number 48. It was pre-filed January 5th of 2020, and it was offered on January 8th, 2020. And I'll read some of it. It says, whereas the Commonwealth has over 200 distinct mandatory minimum sentences spread across at least 37 different sections of the Virginia Code. I didn't actually realize there were that many. That there's over 200 mandatory minimum sentences out there. That seems very high to me, but it is what it is. Whereas mandatory minimum sentences eliminate the discretion of judges and juries to make sound sentencing decisions based on the circumstances of each individual case. And I will say that it does take discretion away from the judges, but for all practical purposes, the juries, yeah, they're bound by mandatory minimum, but frankly, jury sentences are usually imposed to whatever amount in active time that a jury wants to set anyway. Judges very rarely, if ever, suspend any jury active time sentences, so that's really not a big deal. But it's definitely a big deal as far as the judges. Yes, technically the jurors would set the penalty phase and the amount of the penalty. So if they do hear about mandatory minimums, a lot of times in jury trials, I've been in some where a person was found guilty and they'd send a letter to the judge saying, do we have to give them all this time? Can we not suspend the sentence? And then the judge will send a letter back into the jury room essentially saying, you have to follow the law and the instructions. That's really all we can tell you to do. So I guess it does have some impact, but this is really more for judges. It says, whereas according to a 2017 report by the U.S. Sentencing Commission, an agency of the federal judicial branch, African American offenders are more likely to be convicted of an offense that carries a mandatory minimum sentence than individuals of another race. I mean, that may be true just schematically, but the truth of the matter is mandatory minimum sentences are attached to offenses. So it's not like I don't know how that would work out where, these particular charges that carry these offenses, how they could be specifically racially targeted, but they threw that in there anyway, I guess for good measure. I mean, I guess the numbers bear out that unfortunately African Americans per capita face many more criminal charges in general, let alone mandatory minimum sentences. But they threw that in there. I don't really know much about that. I just think mandatory minimum punishments are bad all the way around. But that's just my personal opinion. Color me a biased criminal defense attorney. Let's see. The proliferation of mandatory minimum sentences has spread throughout the Code of Virginia without any review of their use or effectiveness since 2007. Now that's interesting. So are they suggesting that since I'm assuming since the Republicans were in charge of the General Assembly in Virginia that nobody's taken a look at this? I find that hard to believe. And interestingly enough, during other times where both parties have been in power here in the Commonwealth of Virginia, mandatory minimum sentences have been allowed to survive. So I find it hard to believe that it's only been during the Republican administrations that these things haven't been reviewed. That's just a political cheap shot, but maybe I'm wrong about that. I actually moved to Virginia in 2007, so I don't really have a whole lot to add about the political situation prior to me moving here for law school at Regent Law School in 2007, but that's what they say. Then it says resolved. So here's what they want to do. The House of Delegates, the Senate concurring, that the Virginia State Crime Commission be directed to study the use and effectiveness of mandatory minimum sentences. In conducting a study, they'll identify all existing mandatory minimum sentences. So instead of I guess once they're doing the review, it will no longer be over 200. It will be 217 or 233 or whatever the exact number is. Review extant literature to determine whether and to the extent to which mandatory minimums affect crime rates, exacerbate racial disparities in the justice system, promote the goal of uniformity in sentencing, particularly as compared to sentencing guidelines, influence the likelihood of guilty pleas versus trials, and influence whether offenders are held accountable for the offenses they actually committed. Now, I will say this. I don't know if they're going to call me. They probably won't. Maybe they should, because I've done several jury trials involving mandatory minimum sentences. And frankly, where mandatory minimum sentences are involved, I almost always ask for a jury. I don't know many people who don't ask for a jury with mandatory minimum sentences. I know of some. There are some people where the set amount is already set, and yet their lawyers still don't do a jury trial because they're too lazy to do one. But if the baseline is mandatory minimum time, then you should at least roll the dice with the jury. Maybe the jury will have some compassion, or maybe there's just something that gets missed. Whereas if you try it in front of a judge with a mandatory minimum sentence, they know the law, they're going to follow the law, and you're not going to get any nullification. I can tell you that right now. So I'll be interested to see what this study comes up with on that front, because guilty pleas would be much less for me. And influence whether offenders are held accountable for the offenses they actually committed. Okay, well, I don't know how you would do that. The Commission shall also provide information concerning legislative efforts in other states. So they're going to look at other states and what they do, and the federal system to modify or repeal mandatory minimums, including the various strategies employed and evidence of their efficacy. Now, there's been a big push in the federal realm for that as well. I can't remember if it's actually been completed where there are no mandatory minimum sentences in federal court. I have to go back and look at that. I have not tried any federal cases involving mandatory minimum sentences. All of my federal criminal trials in the Eastern District of Virginia have just been, mail fraud, wire fraud, things that don't carry mandatory minimum sentence. They're supposed to report back from its meeting by November 30th of 2020. So they already should have this information. And then the chairman of the Virginia State Crime Commission shall submit to the division of the LAS, which is the Legislative Automated Systems, a summary of its findings and recommendations. Executive summary will state whether the Virginia Crime Commission intends to submit to the General Assembly and the governor a report, and it doesn't indicate whether that was done. The executive summary report shall be submitted as provided in the procedures. So the study's already actually completed, so the likelihood that this is going to happen really soon is very high. So what does this mean for criminal defendants in Virginia? If this gets passed, that means that all the sentencings in Virginia will now be solely judge discretion, okay? So, for example, the law enforcement felony, the assault on law enforcement officers will no longer have the 6-month mandatory minimum. So the courts can still sentence them to 6 months, but A, they don't have to, and B, even if they sentence them to 6 months, they would only have to serve 85% of that, at least at this point, in according to the Code of Virginia. So that's a good thing for people who are facing criminal offenses that, maybe this is their first time. Maybe they've had no other history. Maybe there's some extenuating circumstances and facts about the case, that don't necessarily require a mandatory minimum sentence. Not every case is the same. Somebody that's 18 years old and was just really stupid and young, versus somebody that's 30 or 35 that knew what they were doing and could appreciate, what a mandatory minimum sentence is and things of that nature. There should be that ability for the judge to be able to use their brains. That's what they get paid for with the robe and the power. They get paid to make these determinations. So we shouldn't just have a blanket mandatory minimum sentence on any offense. let the facts speak for themselves, and then let the judges, sentence accordingly. And if the judges don't do their job, then get rid of them. Get another judge. They're appointed here, but they're only appointed for a term of years. And if they're not sentencing the way that they need to be sentencing to protect the society, then all the members of society have to do is call the legislatures, and they'll appoint somebody else. Or you vote the legislators out of office. It's really not that complicated. So there's really just no need for mandatory minimum sentences, in my view, in my opinion. But that's just me. All right. I'll probably be doing another video. I was actually planning on doing a video in regards to something else. But we'll get to that at some later point today, probably. But since this hit the news fan today, I wanted to go ahead and jump on that. And we'll go ahead and deal with that at some point later on. All right. Well, y'all take care.